Negotiable Instruments Act, Section 15, Endorsement. Section 15 of the Negotiable Instruments Act, 1881 defines endorsement by explaining that a negotiable instrument is transferred through the act of signing it for the purpose of negotiation and identifying the person who makes such a transfer. 1. Statutory meaning of endorsement. When the maker or holder of a negotiable instrument signs it, otherwise than as such maker, for the purpose of negotiation, whether on the back, face, on an allonge, or on stamped paper intended to be completed, he is said to endorse the instrument and is called the endorser. Such signing amounts to a valid endorsement if made with the intention of transferring the instrument. Endorsement, therefore, is the act of signing a negotiable instrument to transfer it to another person. 2 essential elements of endorsement. For a valid endorsement under Section 15, the following conditions must be satisfied. A. The person must be the maker or holder. The endorsement must be made by the maker in the case of a promissory note or by the holder of the instrument, and only a person legally entitled to transfer the instrument can validly endorse it. B. Signature must be for the purpose of negotiation. The signature must be made with the intention of transferring the instrument, as a mere signature without such intention does not constitute endorsement, and the purpose must be negotiation involving the transfer of rights. C. Signature must not be as maker. The signature must be made with the intention of transferring the instrument, as a mere signature without such intention does not constitute endorsement, and the purpose must be negotiation involving the transfer of rights. D. Place of signature. The signature may be made on the back or face of the instrument, on an attached slip known as an allonge, or on stamped paper intended to be completed later as a negotiable instrument, as the law permits flexibility in the location of the signature so long as the intention to negotiate is clear. 3. Meaning of endorser. The person who makes the endorsement is called the endorser, and upon endorsement and delivery the recipient becomes the endorsee, while the endorser may incur liability if the instrument is dishonored unless such liability is expressly excluded. 4. Purpose of endorsement. Endorsement transfers ownership of the instrument, enables its circulation in commerce, creates contractual liability for the endorser, and facilitates settlement of debts without cash, thereby serving as a key mechanism that allows negotiable instruments to function as substitutes for money. 5 types of endorsement. Blank endorsement, only signature, no specified endorsee. Special endorsement, specifies the person to whom payment is to be made. Restrictive endorsement, restricts further negotiation. Conditional endorsement, imposes conditions on payment. 6. Legal effect of endorsement. Once an instrument is endorsed and delivered, the endorsee becomes the holder and the endorser may be held liable upon dishonor, while the instrument may be further negotiated unless restricted. The rights of prior parties continue unless legally discharged, and endorsement thereby creates a chain of liability among successive parties. 7. Importance in commercial practice. Endorsement plays a vital role in banking transactions, trade financing, settlement of business debts, and the circulation of bills of exchange in both domestic and international trade. It enables negotiable instruments to pass efficiently from hand to hand in commercial dealings. For more details, contact us.